Director of the Plus Group. We want to thank you for taking the time to join us today for the Plus Group webinar series. Today's topic is Claims Anatomy and Ground Rules. Our presenters today are Jim Welty, Managing Attorney, and Michael Dow, Supervisor of Disability Claims. Both are from Standard Insurance Company. Please note that all lines will be muted during this webinar. If you'd like to ask a question, please go to the question pane on your control panel and type it in. We'll answer the questions at the end of the webinar. Also note that we are recording this webinar. It will be sent to you along with the actual presentation in a follow-up email, and you should receive that by tomorrow. You will also be able to view it at our website at www.plusgroup.us.com. Okay, everyone, I'm going to turn this over to Jim and Michael.
Hello, everyone. My name is Michael Dahl. I'm the supervisor of the IDI claim unit with the Standard.
And I'm Jim Welty, and I'm a managing attorney at the Standard. And we're excited to present Claims Anatomy and Ground Rules today. Let me say another word about Michael. He, of course, is the supervisor of our Disability Claims Unit. And we have a nickname for Michael, and I don't know if you've seen his picture, but this may help explain it. We call him Sergeant Dahl, leader of SEAL Team 6, because his area does deal with some interesting situations. You'll hear more about that today.
And Jim Welty is the managing attorney with our legal department here at the Standard. Jim has many hats here at the Standard, including overseeing our appeals unit for contested claims. Jim has been with the Standard for about 15 years, and over the last few years focuses on our IDI block of business. And Jim is affectionately known as the Fixer, and we'll get into that more here in a few minutes.
Actually, this is my chance as an attorney to do what I love to do, which is to provide a disclaimer. If you're ever involved in litigation involving a Standard Insurance Company policy and they ask you about that slide, please let them know the Fixer term is meant as a joke. But in all seriousness, as an attorney, I am called in to help deal with some situations that happen. So what are we hoping to accomplish during this presentation today? First of all, I understand that as you work with different insurance companies and you've got customers who have to make a claim, which is a tough situation for them, there's this sense that sending the claimant off to the insurance company is sort of like sending them into a black box. No one's really sure what happened during the claim process. So the idea today is to give you some idea of what actually happens at a company like the Standard when a claim comes in. So we're going to show you the life cycle of a typical claim. I'm going to talk about the role of the legal department in the claims administration process, and then we're going to walk you through a real-life claim situation that happened here a couple of years ago that I was involved in both on the claim side and on the litigation side. So with that, I'll let Michael talk about his team.
So the individual disability claim unit here at the Standard is comprised of a few folks, and again, as Jim said, our hope is that this provides some color and just a tangible example of what the claims process is like if a client of yours ever has to file a claim. So first is the supervisor, and then the team is comprised of 8 benefit analysts on the IDI claims unit. The claims unit here at the Standard for individual disability claims focuses on individual, but if the insured also has a group claim, we would handle both claims for the claimant, and we think that provides a lot of value and helps simplify the process for someone at maybe the most difficult time in his or her life. Also on the team, we have some assistants and processors who assist the analysts with obtaining medical records, things of that nature, and providing the insured with the forms that are needed to initiate a claim process. We have vocational case managers here who help us rightly understand one's occupation, nurse case managers, physician consultants, numerous specialties, and then we have a special investigations unit. It's the rare claim that involves fraud, but if that scenario ever presents itself, we have our SIU special investigations unit to assist with that, and of course, our friends in the legal department. So what we want to highlight here in part of our presentation is at claim time, why the Standard? So Jim and I are, of course, biased, but we want to walk you through why we feel strongly about what we do and how we handle claims. So bottom line, the promise that we sell is the promise that the claims area is charged with keeping. At the standard, doing the right thing is in our DNA, and as Jim referred to, sometimes it feels like that the insured is handed into a maze or a black box, and what comes out on the other end in regards to a claim decision. And at the standard, we believe strongly in doing things the right way. One data point to illustrate this is our customer service tracking reports show high levels of customer satisfaction. So I want to give you kind of a 10,000-foot view and then a boots-on-the-ground view. A recent study, 3-month average of March, April, and May of this year, shows that 90% of the standards claimants were satisfied with the service they received. And someone could say, well, you manipulated the data and only surveyed those with approved claims. However, more granular view shows that combined group disability and IDI results show that even 60% of claimants whose claims were denied said they were still satisfied with our service. And again, I hope that helps provide some evidence that we really do believe in doing things the right way, even when a difficult message has to be delivered. So here's the life cycle of a typical IDI claim. So there's the initial phone call, either from the insured or perhaps a representative, whoever may be assisting the insured. Claim forms are sent out after that initial phone call. The claim, once all the needed forms and information is received, is assigned to a benefits analyst, and that person's job is to make the claim decision. But to assist them, they have numerous resources available, including, again, the vocational case manager who renders a vocational opinion. Medical records are reviewed by nurse case managers, physician consultants, whatever expertise is needed to make an accurate decision on the claim. A medical opinion is rendered. If appropriate, financial records are obtained and reviewed. And then a claim decision is made and communicated to the claimant. And throughout this process, the claimant is kept informed of what's needed and why, of where the claim is in the process. Even initially, someone may call and say, hey, here's my situation. Should I file a claim or not? We hold their hand through every step of the process.
I don't want to suggest that there's legal issues and legal gets involved with every claim, but the legal department here at the Standard does deal with claims issues as they come up, and there's 2 attorneys here at the Standard who are available at any point to help give advice to our individual disability claims unit. And here's some of the issues that we're commonly asked to talk about. First of all, contract interpretation. Even though our benefits analysts are truly experts at the various policy forms that we use here at the Standard, contract interpretation questions will come up, or there'll be questions that are generated by a claimant. And so we attorneys do an attorney du jour session twice a week where we meet with benefits analysts who will answer whatever contract questions they have. It's not uncommon for a claimant to present a question regarding a power of attorney. So if someone is planning to help the claimant on their behalf in the claims administration process, we're often called in to make sure that that person is appropriately authorized. It's not common that we do this, but occasionally in IDI, where we have fairly detailed applications for insurance, questions will come up at claim time, especially if a claim occurs within the first 2 years of the policy effective date, whether everything was disclosed at the time of the application, and if there's concerns, do we have a potential for a rescission of that policy? So that's something that legal will weigh in on and offer an opinion. If a claimant is represented by an attorney at some point in the claims process, we get involved so we can have attorney-to-attorney contact and make sure that we're answering the legal questions appropriately. Occasionally, we'll be asked about the advisability of making payments on a claim under reservation of rights. That is, making payments before the final claim decision is made. This happens on occasion. As Michael said, our goal is to do the right thing, and this is most commonly occurring when it takes longer to reach the claim decision than we like if there's issues with getting a medical opinion or something like that. And if in doubt, we'll go ahead and make payments on the claim before the final claim decision is made. And while we reserve the right to question those claim payments if the claim is later denied or closed, we very seldom request any of that money back. So generally, if we make payments under reservation of rights, the claimant gets to keep those payments. Consumer complaints do come in from time to time, both directly to us and through state insurance departments, and legal gets involved to make sure that we are crossing the T's and dotting the I's on our responses. Believe it or not, there are threats of litigation that do come up during the claims administration process, and obviously if there's a threat of litigation, the attorneys get involved. And last but not least, actual litigation. We do have litigation ongoing at any given point in time on our IDI block of business. And I'll talk about that a little later. It's, in fact, a very rare thing, given the number of claims that we have on the IDI side. The amount of litigation we're involved in is really quite small, but it does happen. And when that happens, I'm actually the attorney here at the Standard who's tasked with administering those litigation matters. So, we said we were going to have a sample claim. I will tell you, obviously, the names and conditions have been changed here to protect the innocent, but we are dealing with a doctor claim, and this is an actual claim that came through the Standard a couple years ago that I was involved with both at the claim level as an attorney giving some legal advice, and I was involved with it down the road when Dr. Smith did sue the Standard. I'm going to talk about both sides of that because I think you're going to find this interesting. And this will also give you some real-life understanding of how the claims administration process goes. So Dr. Smith is an orthopedic surgeon, and my guess is that you're writing a fair amount of doctor business. I hope so. We have a lot of doctors who make claims, and I see that fairly often as legal issues come up. Doctors generally have good-sized policies, and doctors are very smart folks. They're very savvy. So Dr. Smith is no exception. By the way, I love the picture there. I assume that is pre-disability because he looks very happy. He actually purchased his IDI policy in 1985 when he completed his residency. Fairly common approach. He bought a small policy then, and I think this is very interesting. He bought this in '85, and Dr. Smith, in real life, actually had a claim fairly early on. He had minor sciatica. He's an orthopedic surgeon, so that limited his ability to work for a period of time. He did have full recovery, but he was paid on that claim for a closed period. And there's 2 points I want to make about that. First of all, Dr. Smith, at that point, is pretty satisfied. He bought a policy, had an issue, and the claim was paid. He was happy about that, but I would also suggest that that shows he understands that he has insurance and how the claims process works. So down the road, when he has another claim, he's familiar with the whole process. He's comfortable with it. So Dr. Smith, after 1988, progresses in his field and becomes a highly respected surgeon and a part-time professor at Harvard. So he's both doing the surgeon work and he's teaching at Harvard Medical School. But Dr. Smith had a problem. Took a trip to Lake Placid right before Christmas in 2010, and Merry Christmas, December 23rd, he has a fairly significant skiing accident with a torn ACL and a hairline fracture of the femur. Based on that, because he's an orthopedic surgeon, which requires a lot of standing, he obviously has a claim.
So we'll walk through the first steps in the claim review process for Dr. Smith. So we receive initial notice of his claim on December 27th, 4 days after the skiing accident. An acknowledgement letter from the Standard is sent out with the needed claim forms 1 day later on December 28th. His attending physician statement is received by us on January 4th. It confirms torn ACL, hairline fracture of his femur. He's in severe pain with an inability to stand or walk. And remember this, file this away. The attending physician statement provides an anticipated return to work date of June 11th. Medical records are received the same day. The insured statement is received on January 8th, The claim is assigned to a benefits analyst who, again, their job is to make a decision on the claim. It's assigned to the analyst on January 15th. It's referred for vocational and medical review 2 days later on January 17th. Then the initial letter from the benefits analyst to the claimant is sent out on January 22nd. The claim approval letter, claim approval decision, is made on January 30th. So, from Dr. Smith's accident to claim approval is 38 days. So while each claim is its own entity, and we're not trying to imply this is normative, it goes to show when all needed information is received, our job is to make a timely and accurate claim decision on every claim we receive. So let's take a look at Dr. Smith's claim once it was approved. So based on the available medical records, the standard has our first follow-up contact with Dr. Smith in August. Now I'll say I think we kind of dropped the ball on this. Remember, the attending physician statement provided an anticipated return to work date in June. We should have followed up around that time. But even though we didn't, Dr. Smith continued to receive benefits from the standard. So Dr. Smith tells his benefits review analyst that he did return to work part-time in early June, and he plans to get back to work 2/3 time by the beginning of the year. So based on his return to work part-time, the standard requests financial information from Dr. Smith. He informs the benefits analyst he won't receive his first payment for the work he performed until mid-September. Then in light of this, the standard requests his financial information for the last 2-year look-back period in order to calculate his prior average income.
So at this point, we've got Dr. Smith, who has a residual claim, and we're going to go ahead and administer the policy accordingly. And this is where I got involved again as a legal matter. Because Dr. Smith told the benefits analyst his last 2 years prior to disability were the worst years for him financially, so he wants us to go back 5 years. So the benefits analyst came to me as the attorney and said, legally, is this something we can do? And I told the benefits analyst, who informed Dr. Smith, the contract provides for going back those 2 years, not those 5 years. We're stuck with that. We need to calculate income as provided in the policy. He can request a review of that decision from our administrative review unit, but we have to follow the policy. And there was a question of why that is, and the answer is fairly simple. Actually, there's 2 reasons. Number one, of course we're going to follow the policy where it's very clear, and it's clear in this case. And 2, it's not a good practice for us as an insurance company to make exceptions in some cases and not in others. We really have to deal with that, with what's in the policy consistently. Sometimes that'll benefit the insured, sometimes it won't, but that's what we're going to do. So we went ahead and calculated the prior earnings based on 24 months income, and I smile a bit at this. This happens from time to time. I got involved again because Dr. Smith had an attorney who contacted the insurance broker, who contacted our VP of sales. And I was then brought into all of this, and we had some follow-up discussions between me and the attorney, and ultimately, even though there was some pressure through the sales area, the standard decided to stand our ground and limit this to a review of the prior 24 months, and the claim was administered on that basis.
So in regards to Dr. Smith's continuing claim with the standard, let's look briefly at what medical issues were involved. So we received medical records about 14 months after the accident that show only occasional pain and a return to very limited work. Dr. Smith used to use a cane according to the records, but he hasn't recently. And in fact, he's been able to get aerobic exercise on his bike at home and even walk around Boston Commons. So he's making progress. The knee is feeling better.
Does anyone know how far it is around Boston Commons?
Yeah.
It's about 1.5 miles. I Googled it. So it's a pretty good walk for someone with a bad knee.
Yeah, so Dr. Smith, he's healing up pretty good here. Medical records from June show that Dr. Smith has been performing surgeries, but that he wears down by the end of the week. So later on in September, The medical records show that Dr. Smith has now even been able to bike up to 15 miles at a time, and he's essentially returned to full-time work, only taking Advil to control his pain, but he's still sore and he's considering taking a leave of absence to fully recover. Then in mid-October, Dr. Smith tells the Standard that he ceased working back in September again due to the knee pain. So the Standard, in light of this new information, provides an updated decision on his claim. We obtain a vocational opinion in October concluding that Dr. Smith's occupation is light strength level. Based on this, we obtain an updated medical opinion from an orthopedic surgeon. Remember the physician consultants that the Standard has. The physician consultant reviews the medical records, and he concludes that in light of the available information, that it demonstrates Dr. Smith could return to full-time surgical work by September and probably as early as June 2011. And remember, that was the first anticipated return to work date on the initial attending physician statement. So in light of all the information that we have, the claim is closed with payment of benefits to Dr. Smith through October. About 15 days later, Dr. Smith appeals. He requests a review saying, hey, Standard, I disagree with the decision to deny my claim, and here's why.
So anytime we close or deny a claim, we offer a claimant, the insured has the right to appeal that decision, and it's an independent review. So it's done by someone outside of the benefits area, and any vocational or medical reviews that are done at that point are done by new doctors or new vocational folks. So he appeals, and it was interesting. He argued on appeal a couple things. He said the Standard doesn't understand the strength requirements of his job, and we don't understand the nature of his disability. He asserted that our vocational data is out of date, and orthopedic surgery is now a medium-strength occupation and includes manipulating patients during the procedure. And he made a point of saying patients have gotten larger over time, and since your vocational data is out of date, it doesn't take into account the size of patients that orthopedic surgeons deal with these days. He also says medically, he tried to return to work too quickly. He hadn't fully recovered from the knee injury and the fracture, and he should have taken more time. He continues to be in intense pain, and he really does need a leave of absence to recover. Our administrative review unit submits the claim file for another vocational opinion, which also results in light level classification, with the understanding that heavier lifting could be accommodated by the hospital through having an orderly or a nurse assist. The administrative review unit also submitted the medical records to a different orthopedic surgeon for another consultant review. And that doctor looked at the records and said, well, he has a normal gait. There's minimal objective findings. In other words, there's no imaging that shows anything that should be wrong at this point. Medication levels are low, and there was a real emphasis on the fact that Dr. Smith had done the walking and the bicycling. That's the kind of thing they look at in the medical records. At about the same time, before the decision was made, we were warned by a friend of his attorney friend, that he was potentially going to sue us. We made the claims decision or the benefits decision to uphold on appeal on January 7th, and we were sued soon afterwards. So I was intimately involved in this lawsuit. Here at the Standard, when the file is handed to an attorney in the litigation matter, we hire outside counsel, and then we're involved in all the litigation process from the complaint to our answer to discovery and depositions. It's a very interesting process. I know this one pretty well. And I was a little bit dismayed to realize Dr. Smith had hired very experienced, very aggressive plaintiff's attorney who we've dealt with before. And when I say experienced and aggressive, we see this law firm fairly often. They like to sue the Standard because they feel like they know what we do, how we do it, and they understand our contracts. And when I say aggressive, I will tell you a couple years ago I was in a deposition where they were deposing the benefits analyst on a different claim, and the attorney made that benefits analyst cry. So I'm not real fond of these folks, but I'll tell you, they're effective. So during the lawsuit, this is the kind of thing that happens. We finally, in November, obtained new medical records showing that there were additional tests done on Dr. Smith. In fact, remember, we upheld the denial in January of 2012, January 7th. He had a knee MRI just a little bit later in January, and that knee MRI showed that the injuries he'd suffered had triggered the development of arthritis in that knee, which of course explained the intense continuing pain. And it gets worse from there for us. In fact, there had been some compensation with his other knee, and all of this had in fact triggered arthritis in both knees. So suddenly we're faced with Dr. Smith having objective evidence of some significant issues with his knees. Based on these records, I mean, again, we want to do the right thing. And by the way, Dr. Smith is still our insured. We look at that and we decide, yes, talking to our doctors, he would be disabled from full-time work in his regular occupation as an orthopedic surgeon. And unless he has a knee replacement, which we cannot force someone to do, we accept that he's going to have those limitations for the rest of his working life. Now, a mediation had been scheduled for December 19th. We're preparing for that, and we go to the administration in our individual unit, and we tell them what the facts are, and we're actually prepared to tender a check for all of the back benefits at that time. Just before the mediation, however, a little over a week before, we take Dr. Smith's deposition. And this is where things got very interesting for us. The deposition. Dr. Smith sitting across a conference table, under oath, with a video camera, finally being asked about things by our attorney. At deposition, while under oath, he admits, and by the way, the slide here uses the word admit, and that's a very careful thing. He didn't tell us the following. He admitted, remember the dates? He actually had returned to full-time work in February 2011 instead of part-time work the following June. That's just a couple months after the accident. He may have been in pain, but he said he had to return to full-time work because he was up for partnership in a new practice and had to show he could do the job full-time. And I really appreciate this from the deposition transcript. He explained he didn't tell us because he did not think we would understand the complexity of his injury. He then admitted that when we contacted him by phone, remember when we finally followed up in August of 2011, he was less than forthcoming in explaining his situation and knew he'd made a mistake. So he knew he should have told us what was going on there. Also, he admitted that he'd failed to inform his other private disability insurer or the state disability department that he'd returned to work full-time. So the mediation revolved around the following facts. Remember, we're prepared to tender this check for back benefits, but now we have the new information from his deposition. First of all, despite his attempt to return to full-time work in February 2011, that should be, he did show a permanent partial disability based on his arthritic knee, and that fact doesn't change. We believe that the medical records do show that he has a current valid claim, and his contract has a value in excess of $800,000. We also acknowledge he didn't provide relevant medical records to the standard before a claim decision, and this is interesting. We tried to hold that against him as though that might impact his ability to beat us in this litigation, and his attorney, very experienced and very aggressive, actually made the argument that it was our fault we didn't get those records because we should have pursued them more aggressively. I'd remind you that was a point in time when we were paying his claim, but that's how attorneys argue these cases. The physician consultant on the claim appeal that we used when we rendered our uphold decision, I have to admit, was shredded. I was in his deposition. This was the doctor, the independent doctor that we used and had a look at the records. He was very confrontational with the other attorney and ended up yelling at the other attorney, all on videotape. That was not going to play well for us at trial. Now, we also recognized that Dr. Smith was planning to transition to teaching, but he also wanted to be able to do some level of surgery. So we felt he had some incentive to settle this case for a reasonable amount. Finally, and this is a big deal, Dr. Smith had lied about his return to work date. So if you look at these bullet points, I'd ask you to picture a mediation where we go and we talk to, our attorney talks to their attorney with the help of a mediator. It's kind of like a high-stakes poker game. And these are the various cards, some of more value than others, that are in the relative hands. So the question becomes, what do you think happened at mediation? We settled, and we ended up buying out the claim for somewhat less than 50 cents on the dollar. So right around a $400,000 amount. And when we've done this, when Michael and I have done this presentation live, we've asked people, and there's been a wide range of guesses on what the settlement would be. Every time, though, we've had someone who said, gosh, 50 cents on the dollar. The question is why, and the reason the question is especially acute here is, you may have noted, we recognize that this guy had a valid claim for the continued life of the policy worth about $800,000. And it does beg the question, why would he settle for less than full value or something as low as 50 cents on the dollar? And the answers are fairly simple. We're willing to pay something because he has a valid claim. We felt, and I think there was some agreement at mediation, that there was a legitimate disagreement about our administration of the claim. If there's a legitimate disagreement, it makes his ability to prevail on his punitive damages count pretty questionable. So we really were looking at contract value and not the exorbitant millions of dollars in punitive damages that they otherwise would have claimed. By the way, their last offer before mediation was well north of $2 million. So the deposition really helped us. Dr. Smith wanted to be able to return to surgical work. We all recognize that even though he had a valid claim going forward, he probably could work, and he wanted to. Part of the reason is he can make a lot more money actually doing the surgical work than he could being on claim. He had concerns about his other insurers and the state insurance department. And at the end of the day, and this is fairly common in these mediations, Dr. Smith didn't want to deal with us anymore. And to be honest, we were okay not dealing with him anymore. He'd made a claim. We wanted to treat him fairly. We'd had a disagreement, and we were ready to go on with our separate ways, and he was ready to go on with his life. So finally, the post-mortem, I would point out, when this claim came in, I'm proud of this. I'm really pleased. We paid this claim very quickly based on the initial medical records. We didn't waste a lot of time. The records were conclusive. We felt there was a disability, so we paid. There was a dispute over the prior earnings calculation, but we followed the contract, and I still think that's appropriate. There was follow-up after return to work. I would point out, we were a couple months late in that, but we paid him in the meantime, and there was never any question of us saying, gosh, if he went back to work in June, we're going to recover some of those benefits. We didn't do that. We did follow up, and we did work the claim after that. There was a valid dispute regarding the medical and vocational issues. There were some legal, and I put this in quote, games after litigation is filed. They didn't disclose that MRI for the longest time. And in fact, had they disclosed it back in January, no litigation would have been necessary. But knowing this plaintiff's firm, they probably thought, gosh, we won't disclose it because we can probably do better in litigation than simply putting the doctor back on claim. So that's the kind of thing, the tactic that's used. We were willing to pay the claim based on new medical records. I want to be real clear about that. When they came in, Dr. Smith was still our insured, and we were willing to tender payment. There was a useful surprise in the deposition just prior to mediation. So I believe that we did have that legal poker game at mediation, but the result was fair. So based on all of that, hopefully you have a better understanding of how the claims process works, both here at the standard, and I think other companies follow much the same procedure, and a better understanding of how legal can be involved in the claim, and ultimately a better understanding of how all of these factors work together in the context of a real-life claim. So now, and I'm not sure exactly how this process works in the context of the webinar, but we're open for questions.
Okay, I do have some questions already for you guys. And again, anybody out there that would like to ask a question, just type it in on the window pane there on the right, but I'll go ahead and get started. First question is, does the example of 38 days from accident to approval include payment of the claim? And if not, in this case or in general, when do payments get mailed out?
Yeah, it would depend on the benefit from date on the claim. If memory serves on this, it did include payment of benefits on this. So it would depend on when the claim is filed, when the insured is stating the date of disability was. But again, I think the big idea in play here is when we have the information needed to pay the claim, we're going to do that right away.
I will mention one more thing, though. This policy, because I'm really familiar with it from the litigation, had a 90-day elimination period. So what we would do in a case like this, and what we actually did, is we acknowledged that he had a valid claim. We acknowledged in that letter what the onset date was, and we said as soon as the elimination period is met, the 90 days, payments would begin as of that date.
Thank you, Jim.
Okay, next question. What is the typical agent's role in the claims process? Any recommendations on what it should be?
I would say ultimately it boils down to what the agent wants. So there's on a spectrum, there's varying opinions or best practices that the standard sees. Ultimately, I think the agent has to do what he or she thinks is right. We're happy to help facilitate communication with the agent. We just have, of course, an authorization form that we have to have. We're dealing with sensitive medical issues. But once that form's completed by the insured giving permission to speak with the agent, we're more than happy to do so. I would say, from wearing my claims hat, it's something that I don't think an agent should take flippantly, as if something did, a small minority of claims get as complicated or maybe contentious as the one we talked about here today. But if that scenario did occur, the agent would be in the claim record. So something to weigh, but bottom line, it depends on how they want to handle it, and standard will adjust accordingly.
And I've got a little follow-up on that as well. When we've done this presentation live, this question has come up every time. And it's a great question because producers do get involved, and there can be some friction sometimes, but it can also be very helpful. So my basic rule of thumb from my legal perspective is we invite producers to assist the claimants in the claim process, to assist in communication with the company, and if they can help the claimant better understand what's going on, that's very useful. What we hope to avoid is producers who are advocating for a given claim decision, because that then can become very problematic and a little confrontational. So we want to make sure that we're providing as much help as we can and the communications are good, but when it comes down to the claim decision, we have to own that ourselves.
And I would say ultimately I think an important takeaway from this and why we're here today is to show that ultimately we're all on the same team. We all want the same thing. So I hope that that's highlighted in what we're talking about today.
Great. Next question. How often is a policy rescinded based on non-disclosure of info on the original application?
It happens. There's two attorneys at the standard who review files that come through for what we call a rescission review. And what we do is we provide a legal opinion on whether we feel a rescission is warranted based on the facts and the law of the given jurisdiction. This will be anecdotal because I don't have the records in front of me, but if you can imagine the number of claims we get in a given year, and Michael, do you know how many claims we get in a given year?
Numerous, in the thousands.
I would guess that I see a rescission review, probably, there's two of us who do it. We probably see one come through the department about once a month, and maybe half of those we do recommend a rescission. So while it happens and we do see those, they're very rare.
Okay. Next, do you have a feel for the percentage of claims settled in mediation as opposed to going to court?
I'm happy to respond to that one. We very seldom at the standard actually go to court, and there's a number of reasons for that. We don't think litigation is very useful if it has to go to trial, and trial is a a win or lose proposition. So I would say the vast majority of our litigation matters in IDI do settle at mediation, and that means to settle, unless it's a very unusual case, that means we pay something, and both sides have agreed that that's an appropriate amount. Otherwise, we wouldn't be settling at mediation. We probably actually go to trial on an IDI case once every 5 or 6 years. It's very rare.
Okay, next, what do you mean that there was legitimate disagreement regarding administration, and how did that fact impact the resolution?
That's in Massachusetts, where a plaintiff is making a claim for punitive damages. The legal standard for being allowed to make that claim has to be proof that there was no legitimate issue in the claims administration. In other words, the claimant, or the insured in this case, has to establish in court that whatever action the standard did was totally wrong, and we didn't have any right to even make the argument regarding the administration of the claim. So if we can get a court to agree that there was a legitimate dispute, that is, we do have an argument that the way we administered this was appropriate, we have the ability to avoid a punitive damages claim. So when I use the term in this case, that's the way I meant it. I think we were able to establish to the satisfaction of the mediator that we really did have a legitimate argument regarding the way we administered the claim, including looking at the 2 years for the prior average earning, our decision when to look at a residual disability claim as opposed to total disability, and our analysis, and especially our analysis of the medical records and the decisions we made based on that analysis. Plaintiffs will always argue that, gosh, the insurance company had no legitimate reason to make the decision they did. They will argue in litigation that we acted outrageously and with conscious disregard for the interests of the insured. That's what plaintiffs argue. So it's that legitimate dispute that is the argument we make in response to that. And again, I feel there was a legitimate dispute here, and I think that was borne out in the mediation. If there hadn't been, or if the plaintiff in this case, the insured in this case, had been really adamant there wasn't, I don't think we would have settled at mediation. I think they would have packed their bags and said, we'll see you in court.
Okay, next is, so the settlement included that the entire policy was terminated and waived his right to that policy. I guess that was part of the settlement.
In 95% of the cases that we settle at mediation, that's one of the requirements that we have. We do occasionally at mediation, as part of the settlement, put people back on claim, but we greatly prefer to buy out the policy and to pay benefits going forward. If someone has sued the standard, if they're that upset with us and they've gone to court, it's generally thought that parting ways is the best thing, and if we can buy out their policy at an agreed amount, we feel good about that. And I think they do too. I think that's the best result.
Great. Next question. With 90-day elimination period, can we presume payments get mailed out at least 30 days after the elimination period to make sure a full month of payments are due?
Yeah, correct. And I would drill down into that a little bit more. I don't know all the background here, but it's fairly common for us to receive calls, whether it be from insured or agents, producers, thinking that a claim can't be filed until the elimination period or the benefit waiting period has been exhausted. And we would encourage folks, if they think there's a claim for disability, to call us ahead of time so that we have the time we need to review the claim and make a decision before, you know, the benefits are due and they need to make their mortgage payment. So I would highlight that aspect of it as well.
Was the broker served in the litigation?
Not in this case.
How does standards...
That does happen.
Oh, go ahead.
That does happen fairly often, but not in this case.
Okay. How does standards claims approval percentage compare to other carriers?
I don't think that's something that we can highlight. That'd be more proprietary, but I would say that, again, we see thousands and thousands of claims, and the vast majority of claims are paid.
Okay. Anybody else have any questions they'd like to chime in with? I mean, if not, and you have questions that you think of afterwards, please feel free to contact your local Plus Group office, and we'll get back to you. So at the moment, that's it. Michael and Jim, I think you did a great job. We so appreciate it. And again, as I mentioned, it will be sent out to you. You'll receive an email by tomorrow with the presentation as well as the audio. And it'll also be hung on the Plus Group website at www.plusgroups.com. And again, if you have any questions, please feel free to contact your local Plus Group office, and also check out our website for future webinars. And we appreciate Michael and Jim for their time today, and we appreciate everyone who attended. Thank you so much. Have a great day, everyone.
Thank all of you.
Bye.